Good morning, this is your Kelso Report for Monday, February 13th, and I'm your host, Clark Kelso. We have cases today dealing with preclusion, parole conditions, family law, traffic violations, and litigation costs. We begin in the area of preclusion. Now, when a plaintiff claims that a police officer has used excessive force in the course of making an arrest, it will often happen that the issue of excessive force may be litigated in the criminal prosecution first before a Section 1983 action can proceed. When that happens, and when the jury in the criminal case has rejected the claim of excessive force and has convicted the defendant or defendants, the issue then arises whether the criminal conviction necessarily results in the dismissal of the Section 1983 action. According to the United States Supreme Court's decision in Heck v. Humphrey, the question is whether success in the subsequent Section 1983 suit would necessarily imply or demonstrate the invalidity of the earlier conviction or sentence. If so, then the Section 1983 suit is barred, because the issue has already been definitively determined in the prior criminal proceeding. The Ninth Circuit faced this issue in Friday's decision in Beets v. County of Los Angeles, where the parents of a young man who had been shot by a police officer were suing under Section 1983 for use of excessive force. According to a prior criminal indictment, the young man and his companion were allegedly engaged in an assault on a peace officer with a deadly weapon when the peace officer shot the young man. In the course of that criminal proceeding, the jury convicted the young man's accomplice, and in the course of making that decision, determined that the peace officer acted within the scope of his employment and did not use excessive force. Because a successful verdict in the Section 1983 suit would tend to undermine the criminal conviction, the Ninth Circuit held that Heck's preclusion applied, and the court dismissed the plaintiff's Section 1983 claim. Next, we turn to an issue involving retroactive parole conditions. The Nevada legislature enacted two bills expanding mandatory requirements on sex offenders. The first bill expanded the scope of sex offender registration and notification requirements. The second bill imposed residency and movement restrictions on certain sex offenders. Now, it originally appeared the state might try to enforce both bills retroactively, and the ACLU sought and received preliminary injunctive relief barring enforcement of both bills. The state ultimately informed the federal court that it did not intend to enforce the new residency and movement restrictions retroactively, mooting out that part of the state's appeal. As for the registration and notification requirements, the Ninth Circuit held that it was constitutional to apply those new rules retroactively. With respect to these requirements, the Ninth Circuit concluded the Nevada legislature did not intend to impose any additional criminal punishment, that its intent was simply to enact an expansion of a non-punitive civil regulatory program, and that its purpose and effect was not so punitive as to negate the state's intention to deem it civil. The Nevada Act was patterned on the Federal Sex Offender Registration and Notification Act, and the retroactive application of that act and other state acts patterned on that act had been repeatedly upheld by other federal circuit courts. Now we turn to an area of family law. California courts often follow what is known as the time rule for apportioning a pension's community and separate property interests. Under the time rule, the community property interest in retirement benefits is the percentage representing the fraction whose numerator is the employee spouse's length of service during marriage before separation, and whose denominator is the employee spouse's length of service in total. The separate property interest is, of course, the percentage representing the remainder of 100% minus the community property interest percentage. Well, in re Marriage of Thorne and Racina, the 6th District considered a case where the parties had agreed in a settlement that Laura would accept 16% of Stephen's military retired pay starting in 2008, based on his rank and pay level at the time of the dissolution judgment. The court had entered a stipulated marital dissolution judgment in 1999 based on that settlement agreement. A little over a decade later, in 2010, Laura sought to set aside the judgment because she had learned about the time rule, and their settlement didn't conform to it. The 6th District rejected Laura's attempt to change the judgment, concluding that there was no extrinsic fraud, the court had not reserved any jurisdiction to modify its judgment, and the judgment specifically had dealt with the issue of the allocation of the pension. Under these circumstances, Laura had no basis for modifying the judgment, and the court even had no jurisdiction to modify the judgment. She stuck with her settlement agreement. Next, in the area of traffic violations. Red light cameras. They're not all that popular with the public. And every now and then we see courts throw a monkey wrench at the whole enterprise. That's what happened in People versus Borzakian, where the 2nd District held that the police officer who handles all of the records regarding the City of Beverly Hills automated red light enforcement system, and who appears to testify at all contested violations, could not authenticate the maintenance records for the cameras, which actually were maintained not by the police department but by a private company which contracted with the city. Absent authentication, the maintenance logs were not admissible, and absent the maintenance logs, there was no basis for asserting the reliability of the red light camera that snapped the defendant's picture. Case dismissed. A big win for drivers. Finally, we deal with the area of costs. We don't see very many published opinions about what is and is not an appropriate basis for an award of costs. But the 2nd District faced, in Martinez versus Brown Co-Construction, a $92,000 costs request for preparation of a PowerPoint used in closing argument. That's one hell of a PowerPoint. $12,000 for editing of a video deposition played to the jury, and $188,000 in expert witness fees, which were incurred after the plaintiff's first Section 998 offer and before the plaintiff's second Section 998 offer. So big money was at stake, and the court had the interesting legal question of how to treat the second Section 998 offer, hence the published opinion. Well, on the PowerPoint, the 2nd District held that because it contained nothing but argument of counsel, costs for its preparation would be inappropriate. The costs for the video deposition were reasonably necessary, particularly since the jury specifically asked for the video in lieu of a dry readback. And as for the 2 Section 998 offers, the court held that the plaintiff was entitled to expert witness costs incurred from the date of her earliest reasonable offer. Well, that's it for today's Kelso Report. Have a great day in the law.